assess the entire ruling in its entirety, and the court was very specific in assessing how we got to where we are. And there's a very large portion of the ruling dedicated to assessing how much interference, both direct and indirect, was employed to ensure that the cases were terminated, and finding itself at that place. So it's important for us, even as we celebrate, we think about the victims who are particularly participating in this case. I do not think victims are celebrating at this time. It's an unfortunate place we find ourselves, because it is not a clean termination of the case. The case has not undergone the full logical progression to the conclusion because there was interference. It's a mistrial, not because the prosecutor completely failed to provide sufficient evidence, and the decision is very clear on that. The circumstances within which the prosecutor was collecting her evidence was interfered with and presenting her evidence. So it's an unfortunate thing.
Disappointment, frustration. You've already stated that you're pleased with the ruling. What do you make then of these senses of disappointment and frustration?
Yep, I think I need to just be able to actually say that yes, indeed, we are pleased with the decision, but there's a sense of relief. And it's not a sense of relief just on the part of the Deputy President and Mr. Sang and the Kenyan government, but also even for the victims. And I have in mind this morning, a man called Joseph Githuku, who was a victim, in the Kiamba church. The one indeed, his story is in the papers today. I mean, basically saying, look, I lost my wife and I lost my son, but I was really praying for this verdict, because it cannot be, that these two individuals, would be the ones that bear the entire weight of what happened in 2007. And so on the one hand, I think there's a sense of relief, but also on our part there's really a sense of disappointment, because what we have seen on the part of the judgment is that the court has looked for a very clever scapegoat, which is to say this case has collapsed because of interference, instead of actually ascribing failure to the prosecutor, who from the word go went on a fishing expedition, and did not investigate this matter. So we are disappointed in that regard.
Okay, and then your question.
That's my question.
Yes.
That the court is telling us that if a situation like this arises again, all the government does or politician do is meddle. Therefore, the case will be lost. It means they are not in a position to do anything.
I don't think that is correct. I don't think that is correct. And the reason I say this is that it must not be forgotten. And I think between yesterday and today, it has been forgotten that as we speak, there are 3 persons who have been charged with witness in connection with witness interference. And so, like Stella said, even as whoever is celebrating celebrates, it must be remembered that there are other processes that will probably have to be taken to their logical conclusion as a result of the witness interference that has been mentioned in the decision.
Do you see those people going to the Hague?
Well, a lot will depend on political will. The government is required to cooperate, and I am hoping that if not for any other reason, the fact that now the case has been terminated against Mr. Ruto and Mr. Sang, I'm hoping that that then should set the stage for the country to say, for the government to say that we are no longer withdrawing from the Rome Statute, because it is only within the confines of being part of the being a state party to the Rome Statute that the Kenya government would be able then to discharge its obligations, which are there in the under the statute and in the International Crimes Act, for assistance in terms of arrest and surrender of the persons who have been charged to the ICC.
You've gone. Did you want to say something, Ms. Ndirang?
Yeah. Just in addition to what you said, in terms of how this case has played out, I think for the ICC, this is an opportunity to learn lessons on how to secure their evidence and how to secure also witness protection and make it better. I know there's been effort to try and improve their witness protection program, because most of the allegations that accrue to the interference are with regard to witnesses who are key witnesses for the prosecution. But also, I just want to say also, as a country, in reviewing this, I think a lot has been said about the ICC process, but I think the same type of interference and meddling will be seen also locally, because I think a template has been set that if you don't want a case to proceed, just interfere with the evidence. And
it sets a bad precedent.
Exactly, even at a local level.
Okay, but respond to Dr. Singwe's comments, therefore, because you say that the case was terminated because, not due to the prosecutor's incompetence, but due to the external factors beyond her control. Witness interference, political meddling. But Mr. Singwe calls it a fishing expedition. So where should we be?
I think for me, I draw my conclusions from the decision, because anyone seated here analyzing the decision does not have the totality of the evidence that was produced, and that the judges...
But we do have the ruling, yes.
We do have the ruling, but we do not know how much evidence was given to the judges to assess. But based on the ruling, it is clear that the judges say that they have deduced from the evidence that was presented before them that the presentation of the evidence by the prosecutor and even investigations were marred with interference, and this could have influenced the environment within which the prosecutor was collecting and presenting evidence before the court. And so it is easy to label the prosecutor as having been incompetent, having fished, having not secured enough evidence, but we have all the evidence that was presented. Some of this evidence was presented in camera, remember? Some of it was not presented in open court. Some of it we don't even know was documentary evidence. So it is easy to draw conclusions, but personally I think it's difficult to know how much the judges had to work with and whether it was sufficient and could have been sufficient if there had been no interference.
But there have been arguments that in the first place the decision to prosecute the six was wrong, that they were not the main combatants in this political fight. That's why he's saying they brought up the wrong people. First of all, they resist the four, they left the two. Now the two. That's the main problem. The initial problem was a campus problem. What do you say to that?
For me, the argument about whether the six were the wrong people or not is an argument that has been explained over time, because what would have been the practicalities of prosecuting Kibaki and Raila at the time? Remember, we had just come from a very violent season after an election. So you're suggesting that we needed a leadership vacuum so that we could prosecute the two topmost, and then again under the Rome Statute it says the most responsible. It doesn't necessarily mean that the people who were taken to the court were not the most responsible. They were part of the most responsible. Again, the ICC is a court of last resort, and primacy to investigate and prosecute lies with the national system. Let us not forget that before even Ocampo came to Kenya, there were numerous efforts to try and push the Kenya government to initiate investigations and to prosecute. I remember before even Ocampo did initiate his investigations, did apply to the pre-trial chamber to be given permission, he actually came to Kenya, met with the two principals, President Kibaki and Raila, and they even held a press conference after that saying, we have been unable as a country to initiate investigations and prosecutions and to set up the special tribunal that had been recommended by the Working Commission. And they said, we give you our blessings, go and initiate investigations and prosecutions. And so we need to go back to that original narrative often, because the narrative along the way has been changed because of this campaign to ensure that a certain narrative takes its root. Parliament itself, the legislature said, let's not be vague, let's go to the Hague, let's not establish a special tribunal, let's go to the Hague. And we found ourselves there, not because of the ICC's insistence, it is because we're the ones who insisted we could not do it at a national level.
Thank you.
Yeah, you know, I think it's really unfortunate to suggest, even for a moment, that Kenya was accorded the opportunity to be able to conceptualize a mechanism, you know, that would address the post-electoral violence. Kenya was never given the chance. They were told it's either A or B. Whereas the answer could actually have been entirely different. Here is a country that had been traumatized, you know, by 3 weeks of conflict. A country that is recovering, dealing with a huge humanitarian crisis in its hand, you know, trying to resettle people. Okay? And you are confronting this country with only 2 options. And you're saying you've got to do that within a 6-month period. Honestly, how fair can that be? Do you expect these individuals, the political actors at the time, to actually have the presence of mind to think through the issues? And so our argument has always been that this was an intervention, an external intervention, you know, that was untimely. You know, its time had not come. Kenya could have been given a couple of years to think about these processes and to formulate, you know,
but
to formulate
did they ask for that time?
They did.
And were they given?
They were never given, any time.
Several extensions.
Absolutely not. I mean, look at it. Look at it. I mean, this matter was pursuant to the Working Commission report. Now, the Working Commission report came out late in 2008. Okay?
October, precisely.
October 2008, indeed.
Yeah.
All right? When did the ICC intervene? By 2009, November, which is just a year later, the ICC had already intervened. Okay? Surely, are you saying, given the complexity of all those issues, given the political character of our polity at the time, you know, were we even given the time and the facility to be able to deal with that? I don't think we were. And so there was a clear attempt on the part of the international community and the civil society groupings at the time to externalize this problem so that they could have space for interference. And so this interference, in fact, that they're talking about right now, that they're using as a scapegoat, you know, is something that has been conscripted from the very beginning.
Sorry, when you say interference being conscripted, you mean that the court, the judges of the court, excuse me please, have also been conscripted by this?
The interference I'm talking about is the fact that the narrative around the failure of the Kenyan state had been driven, you know, by various international actors, you know, using certain actors within our civil society, you know. And so for us as a state, this constitutes interference. It's a bigger, it's a broader, it's a more complex kind of interference.
But then what do you make then of the judges? Because you have said that the prosecutor, starting with, you're talking about Ms. Bensouda, but of course Mutegi pointed out that there are those who think that the problem started with Mr. Ocampo. You have called it a fishing expedition, yet the judges ruled to say that they did find evidence of meddling, they did find evidence of political interference.
It's putting the cart before the horse. There has been no trial at this point in time regarding whether or not
no trial, you know, even though we have instances of people.
There are mere allegations at this point in time. They have not been tried, they have not been tested, you know, they've not been challenged. These are mere allegations at this point in time. Okay?
You wanted to come in?
Yes, I wanted to come in and say a number of things. First of all, we need, as Stella says, to go back to the original narrative. And this is the original narrative, that the prosecutor, then Ocampo, asked if he could commence an investigation here. That was a judicial decision. There was a judicial decision that followed after that, and the court deemed it fit to open an investigation. Thereafter, the court deemed it fit to name certain people as suspects. They went through a confirmation hearing, yet another judicial process, and at the end of it, the court was convinced that there were people that need to stand trial. What I'm trying to say is this, that there cannot be any reasonable argument that this was a fishing expedition. At every level, you can see that there was material sufficient for the court to proceed upon. And that perhaps is what answers what Dr. Singwe is calling untested allegations of witness interference.
And what does Dr. Singh say about the effort by even Raila and Kibaki to convince Parliament to set up a local tribunal?
Yes, in fact,
the Parliament refused.
In fact, I want to get to that.
Yeah.
I want to get to that and say that, first of all, if we are saying that this case was a fishing expedition, then I would want to say, logically, then there would even not be any allegations of witness interference. That should follow as the night follows day. That if you're saying that there was such a weak case, then why is it that we would be seeing the recantation that was taking place? Why is it that we would be seeing witnesses, including dual status witnesses who are victims, being subjected to threats? There would be absolutely no reason for that.
Let's give you an opportunity and then we can take a break.
Thank you very much. I think Mutegi raises a very important issue, you know, that Parliament basically failed to set up this tribunal. But again, Mutegi, I think you must understand that part of the attraction with the ICC at the time was that the ICC was held out as this utopia, you know, as this alpha and omega of, you know, of justice, as this pedestal, you know, that you cannot quibble with. You know, this attraction as against the Kenyan judiciary at that point in time, you know, it was very obvious to everybody that, yes, you know, we must go to The Hague. So it wasn't an unreasonable proposition. People actually thought and believed.
I think
that this was a
has to do with you are saying that
of pursuit.
No, Mutegi's point has to do with the point you made.
I was not given a chance.
Yes.
Right.
In fact, I wanted to get back to that.
Not given a chance.
I wanted to get back to that and say that it was in mid-May that the commission investigating the post-election violence was constituted, and by October they had delivered. That was a space of less than 5 months. They had delivered, including setting up all the structures. You see, without a pre-existing structure. Parliament was...
So what is the now?
Just 1 minute. The Parliament was a pre-existing structure for the enactment of the special tribunal. And, in fact, there were efforts by former Justice Minister Martha Karua to put that up together. I was part of that committee. We drafted, and you know, in January of 2009, we had the bill ready. The bill was shot down by the same people who later on were going and saying, no, now we want to move away from The Hague. After having said, don't be vague, let's
go to The Hague. Okay, so now we've got to take a break. This is Cheche. We're live on Citizen TV. We're unpacking the ruling, but the focus of our conversation this morning on the ICC ruling is what next? Our SMS number is 22422. Tweet us using the hashtag Cheche.